Hello, hi everyone. Welcome back to the channel. We are here again with another part-packed session on Law of Torts. That is, we are going to cover the part 2 of Law of Torts. And Fadafit say, tell me that am I perfectly visible and perfectly audible to you all? So last time we actually covered all few of the concepts of law of torts and we did the few of the questions from the past year itself. This time again we are here with another few of the questions of law of torts and then we'll be moving ahead with another subject very soon. So I hope you all are here. Just give me a thumbs up whether I am perfectly visible and audible to you all. Okay, so let us start with our first question. First question is on injunction. Injunction एक ऐसा टूल है जो काफी सारी लड़ाई झगड़े होने से बचा सकता है. So that is injunction is a very nice tool that we have with respect to the concepts that we have in torts. So yes, injunction is something where you ask the person not to do something or to do something so that the inconvenience for the person is reduced. Suppose there is a way and then another and there are two people who live side by side and then one of them actually stops the way because of the construction. Maybe आपने देखा होगा there are a number of constructions going on and there are neighbors और neighbors के चक्कर में उन्होंने construction को रोक दिया है. Sorry, way को रोक दिया है और way पे there are a lot many things that are there. So to remove them you can just ask and the to उनको remove करने के लिए अगर कोई कोर्ट का ऑर्डर आता है कि आप प्लीज राइट टू वे दे दीजिए, that is an injunction. So injunction basically can be given to actually किसी चीज को हटाने के लिए या किसी चीज को यू नो रोकने के लिए you put injunction for. So yes, an injunction. So this is a problem where injunction is actually there. So principle states an injunction is an order of a court restraining the commission, repetition, or continuance of a wrongful act of the defendant. As I said, it's commission, repetition, or continuance of the wrongful act of the defendant. To entitle a party to an injunction, he must prove either damage or apprehending damage. The apprehended damage must involve imminent danger of a substantial kind of injury that will be irreparable. Basically, it's an injunction given to another party. कोर्ट का एक ऑर्डर होता है, ठीक है, रिस्ट्रेनिंग के लिए, कमीशन, रिपीटिशन और कंटिन्यूएंस ऑफ अ रॉन्गफुल एक्ट के लिए, and damage or apprehended damage control करने के लिए, right? So facts is X, a senior citizen, rented an apartment in a colony meant for retired officials. The area was calm and serene with very less noise pollution. So यहाँ पे there was a citizen who was living in an apartment who used to live in a retired official apartment, right? He was a also the area was very calm, very serene with very less pollution. X intended to impart piano lessons to students from his apartment. पियानो के टीचर होंगे, एक्स तो अपने स्टूडेंट्स को पियानो सिखा रहे हैं. The residents of the area resisted the idea and tried to convince X against the same. So yes, the residents of the area were not happy because obviously it was calm, serene area. So they just convinced X, resisted the idea with the same. However, X tried to give reasons to them that he will regulate the number of students and impart lessons at such hours that no inconvenience will be caused to residents. The residents of the area moved to court seeking an injunction against X on the ground that his actions may cause nuisance to the residents. Now, whenever you're going to solve a legal question, this is the first and the foremost thing you should know. Ki whenever you're going to solve it, always remember to give more focus on, more emphasis on the principle, because there might be certain nuances which you might not read and which is totally different from your concepts that you might have actually read. So facts are here. The facts are similar. We know what facts are. So basically, injunction here is an order restraining the commission, reputation, conveyance of the wrongful act of the defendant. These are the essentials that we have from the principle. And what are the essentials? To entitle a party to an injunction, what should be done? He must prove either damage or apprehended damage. So was there an apprehension of damage or not? We have to make sure that that is also there. The apprehension damage must involve imminent danger of a substantial kind of injury that might be irreparable. So what there is an where अगर वो पियानो की क्लासेस ले रहा था X, क्या वो apprehended danger में था, ऐसा कुछ था कि जिसकी वजह से इंजरी हो जाएगी और जिसकी वजह से it would be irreparable damage to them? क्या ऐसा कुछ था इसलिए वो उनको इंजंक्शन लेना चाहिए था? So we'll see the options now. An injunction against X cannot be granted as he has not caused any damage. An injunction against X can be granted as damage is apprehended by the residents due to nuisance that might be caused. Injunction against X cannot be granted as apparent danger is not substantial or irreparable. An injunction against X can be granted as the idea of opening a music school has disturbed the residents, thereby causing them mental agony. So, what should be the answer? Good evening, Adrija. Good evening. What would be the answer? Fatafat, tell me. The answer to the same would be C, because yes, an injunction against X cannot be granted as the apprehended danger is not substantial or irreparable. The damage was not that substantial and that irreparable that वो कहीं ना कहीं किसी इंसान को इतना ज्यादा डैमेज पहुंचा रहा हो. That's why there would be no injunction granted. Next question is on the violation of legal right without causing any harm, loss, or damage to the plaintiff is actionable per se. It's a normal principle per se, and a violation of legal right. Let's see the facts of the same. Bhim and Sen are friends. Bhim is elected as a member of the state legislative assembly. So Bhim and Sen were two people who were really friends, और उनका उनमें से Bhim got elected to be a member of state legislative assembly. On the first day of the new session of the assembly, Bhim reaches the assembly premises accompanied by Sen. Sen tries to enter the assembly along with Bhim. Both Bhim and Sen are detained by the police but are released after a while. However, due to police action, Bhim misses the session of the assembly for the day. Both Bhim and Sen file a separate suits for false imprisonment beside. So now, what is our principle stating? A principle is stating a violation of a legal right without causing any harm, loss or damage to the plaintiff is actionable per se. So here they are just saying कि अगर किसी का भी legal right harm होता है without any harm, loss or damage to the plaintiff is actionable per se. यहाँ पे actions लेना ही लेना है, right? Now we have 4 options. Now which would be the correct option? Get me the answer. Why A? So options देखते हैं. The suits will be decided in favor of Bhim and Sen as there has been a violation of the legal rights of both Bhim and Sen. The suit filed by Bhim will be decided in his favor. The suit filed by Sen will be decided in his favor. Both the suits will be dismissed in a no cause of action. ओके सो यहाँ पे भीम एंड सेन दो लोग थे. भीम वॉज वॉट मेंबर ऑफ अ स्टेट लेजिस्लेटिव असेंबली. ही वॉज अ मेंबर ऑफ द स्टेट लेजिस्लेटिव असेंबली बट सेन वॉज नॉट, राइट? सो भीम का क्या था? भीम हैज द लीगल राइट टू गेट इनटू द असेंबली, वेयर एज सेन डिड नॉट हैड एनी लीगल राइट. सो सेन के तो कोई लीगल राइट्स वायलेट ही नहीं हुए. अगर सेन का कोई लीगल राइट वायलेट हो रहा होता देन वी कुड हैव कंसिडर्ड, बट सेन का तो कोई हो ही नहीं रहा, तो दोनों तो सी ऑप्शन तो जाएगा ही नहीं, ठीक है? डी ऑप्शन भी नहीं जाएगा. ए ऑप्शन में भी भीम एंड सेम दोनों की बातें हो रही है, तो ओनली ऑप्शन दैट वी हैव इज बी, वेयर भीम की बात हो रही है. सो यस, भीम हैड दैट लीगल राइट. सेन के पास तो ऐसा कोई लीगल राइट ही नहीं था, तो सूट फाइल्ड बाय भीम विल बी डिसाइडेड इन हिज फेवर. सेन के पास, तो आंसर वुड बी बी, नॉट ए, सी और डी, नन ऑफ दैम. ओके. Next question, we have a principle where a person consents to the infliction of some harm upon himself. He has no remedy for that in tort. अगर कोई इंसान अपने आप को हार्म कर रहा है तो उसके लिए उसके पास कोई रेमेडी नहीं है अंडर द टॉर्ट्स. Let's see the facts. Arjun, a sports journalist, went to cover a bike race at KP International Circuit. The journalists were seated in the press box and were instructed that they could interview the participants of the race and enter the racing arena only after the race was over. After the race, Arjun went to track to interview the owner of the winning team. Ranbir, the winner of the race, was taking victory laps, raised his hands, and lost balance of the bike. As a result, Arjun was injured. Arjun brought a suit against Ranbir for causing injuries. Decide. Same question हमने last time किया था. So, any answers that you guys have? Arjun has no cause of action as he consented to suffer infliction of harm when he entered the racetracks. Arjun has cause Arjun has cause of action as he had knowledge of injury but did not consent to suffer the same. Arjun has no cause of action, it was inevitable accident. Arjun has cause of action as the injury was caused by negligence of Ranveer. What would be the answer? हमने लास्ट टाइम ही क्या था, वॉलंटरी नॉन फिट इंजरी में we saw the similar kind of case. What would be the answer? The answer to this would be D because yes, अर्जुन ने खुद consent किया था to go there. तो अर्जुन cannot ask or can file anything against Ranveer. So Arjun has cause of action. The injury was caused by negligence of Ranveer. Why it would be B? Here, when you see the facts, you will realize that Arjun Arjun went to the track after just after the race was over. So here he submitted his consent for non-risk arena. तो when the race was over, there was no risk. उसको जब permission दी गई वो तभी गया. He was not sitting there watching the race. जो हमने लास्ट टाइम एक क्वेश्चन किया था उसके अंदर भी रिमेम्बर कि वो देयर वाज अ लेडी हु वेंट टू सी द रेस and she signed the form where she's approved for the any of the risk that has to be taken. Here he did not sign up for any kind of risk. So when everything got over, when we were just taking the labs and there was no risk zone. This was risk-free zone. That's how it would be negligence of Ranveer. Here, Arjuna's cause of action as the injury has was caused by negligence of Ranveer. So last time there was simple kind of change of facts. Here also it's a change of facts. Now you understand? Here they were sitting in the press box and were instructed that they could interview the participant of the race and enter the racing arena only after the race was over. Next, a plaintiff cannot be met with the defense of himself being the wrongdoer unless his act is the determining cause of harm suffered. Okay, so the plaintiff, a bund was built over River Juru by the government to prevent the river water from entering the nearby fields. After the completion of the dam, allegations surfaced that substandard materials were used for the construction. An inquiry subcommittee set up to investigate the matter came up to the same conclusion and declared the bund unsafe. A notice was put up by the government instructing the farmers to avoid over irrigating the fields so as to prevent waterlogging, as it might lead the bunds to collapse. One day, Ankit, who owned a farm near the bund, left his tube well open, causing waterlogging near the bund. As a result, the bund gave away and nearby farms were flooded, causing damage to crops. Ankit filed a suit against the government claiming compensation for the loss caused to him. The government took the defense of Ankit being the wrongdoer decided. Ankit can be met the defense of himself being the wrongdoer as his actions were determining cause injury suffered by him. Ankit cannot be met with with defense of himself being the wrongdoer as his actions were not the determining cause of the injury caused to him. Ankit cannot be met in the defense of himself being the wrongdoer, but he can be led liable for the contributory negligence. None of the above. Decide. Here he actually put the hand pump open, and because of that, there was a flood, and because of that, the crops were damaged. So, yes, the answer would be A. Ankit can be met with the defense of himself, being the wrongdoer, as his actions were the determining cause injury suffered by him. So, here the plaintiff cannot be met with the defense of himself being the wrongdoer unless his act is the determining cause of the harm him suffered. Here he can apply because he was the one person who actually made the act done. Next, inevitable accident serves as a good defense in an action for torts. Goni bought a new sports bike for his son Jadu. On a rainy day, Jadu took his bike for a ride. Since it was raining heavily, very few people were using the highway. On a turn, Mohli was trying to cross the road, and Jadu suddenly found Mohli in front of his bike. Jadu was riding the bike at a fairly high speed. Jadu applied the brakes, but since the road was slippery due to rains, he lost control and injured Mohli. Mohli brought a suit against Jadu for causing injuries. Decide. Inevitable accident serves a good defense as an action of torts. So, what is inevitable accident? Inevitable accident is one where you could not have been prevented anything, which despite of taking all the reasonable precautions. So here, in this case, actually, Jadu was riding at a high speed, right? Or it was a rainy day which was there. Knowing कि roads में तो road would be slippery और visibility will also be very poor. Reasonably prudent person अगर कोई होता, if there was a reasonable prudent person, he could have exercised more cautious towards the same. Since the accident was unavoidable, accident was avoidable with reasonable care, and his conduct actually was not of a prudent man, Jadu will not be able to have the defense of inevitable accident applied. So yes, the answer would be A, where he has actually lacked the due care and reasonable, reasonableness. Yes, so that's why the answer would be A, where Jadu cannot claim the defense of inevitable accident. That is it for the today. We have 5 questions done. Next I will be coming up with another subject session. So maybe constitutional or criminal. Stay tuned next Monday at 5:30 p.m. Bye bye, students. Take care.